possible action, hearing and discussion to affirm, modify, reverse, or remand an administrative hearing officer's hearing order remanding and modifying a code enforcement violation of Washoe County Code Section 110.306.35B, outdoor storage of an RV on a vacant parcel without the required existing principal use. Once again, it is Chad. Chad, you were up on this.
Chad Giesinger, Planning Manager for the record again, and this is item 8D, and this is an appeal by the actual code enforcement program of an administrative hearing decision. So just by way of a little bit of background for the board, so you don't hear these cases very often. When code enforcement issues a civil penalty, the respondent, the violator, in other words, has two options. They can either pay the fine, well, three options. They can either comply, they can pay the fine, or they have the right to appeal to what's called the administrative hearing office to make the case as to why they feel they're on a violation. So when that hearing is held, the administrative hearing office either affirms, modifies, or dismisses the subject violation based on testimony from the two parties and the evidence presented, and then they issue what's called an administrative hearing order. The item before the board today is an appeal of an issued hearing order that did not affirm a violation case in WIO 24-0100. Rather, it modified it, and it also has some perplexing direction and language in it, which I'll get into further later on in this presentation. So Chapter 125 of Washoe County Code, known as the Administrative Enforcement Code, states that if there's an aggrieved person after a hearing order is issued, that they have the right to appeal to the Board of Adjustment. And I want to make it clear on these types of cases, the next step after this is not to the Board of County Commissioners, as was read in earlier. In this instance, this process, the next step would be judicial review. And that would be the final step of the process. So some background on this property. It's located in Warm Springs at 300 Powderwaw Springs Road in the foothills of the Powderwaw Mountain Range, so it's pretty far up on the east side of the Washoe Warm Springs Valley. It's a 104-acre undeveloped property with significant topographical constraints. There's no utilities or infrastructure on the property, and the regulatory zone is general rural agriculture, which allows a primary use. A typical primary use would be one dwelling unit per 40 acres. Here's a map of the subject location. You can see up there by the word pyramid, just below that is where that Wild Horse Adoption Center is. Just for reference, you can turn there and work your way back up in there. So background on how this case started. It was an anonymous complaint was received by code enforcement way back in January of 2018. And the complaint alleged someone was living in a trailer and had placed some car containers, all without any improvements to the property, such as a well, septic, garbage collection, or a house. Code enforcement opened an investigation, and at first we couldn't verify the RV component of it, but we did confirm there were outdoor storage of materials in view. We worked a separate case on that, and there was compliance achieved on that, but subsequent investigations did confirm there was an RV on the parcel. And since it did not have an established principal use, that's a violation of Washoe County Code 110-306-35B, storage, outdoor storage on a vacant parcel. So after the owner received the violation in August of 2018, code enforcement met with them in our offices and provided a compliance plan. It had two options. One was really straightforward, move all the items. The other one, a little more complicated, obtain a building permit and construct a single-family house. And by doing so, that would allow accessory uses such as the storage of an RV. And the owner chose to pursue the second option. Because it takes time to get a building permit, in this case it took a long time to get a building permit, an extension of time was granted for them to work on submittal. It wasn't very timely, so some additional EOTs were granted, but a building permit was finally issued in November 2019. This is the building permit number that was issued for a very simple, small dwelling that met the components of a habitable dwelling. So a bedroom, a bathroom, and a kitchen. It's kind of a kit barn cabin type structure. And the reason that's important is because Washoe County Code 110-310-35A, temporary uses, does allow a property owner, it has an exemption to the outdoor storage provision, where it allows a property owner to reside in an RV when when they have an active building, when they have an issued building permit to construct a permanent single-family dwelling, and while the permit remains active. Now, there are some time limits on the length of time you can do that, and I'll explain that in further detail later. But based on the scope provision, we were able to close the RV case while they pursue construction of the dwelling. However, as I mentioned, there's some time constraints involved here, both for the RV living and the building permit process. So in order to keep a building permit active, regular process has to be demonstrated. And process basically amounts to having at least one inspection every 6 months. And there's many steps involved in the construction of a home, many opportunities to have inspections at each of those steps. Also, the building code, chapter 100, states that construction authorized by a building permit has to be commenced within 6 months, and it cannot be suspended or abandoned for more than 6 months at any point. And then just in general, the building permit automatically expires after 18 months and must be renewed if the project has not been completed. The building official has the authority over all that process and may grant extensions. So in this case, the property owner did not commence work within 180 days. They had not completed any work towards building the project after 18 months. However, due to COVID, the building department did issue an extension due to extenuating circumstances around COVID. This was common during that time in May of 2021. Unfortunately, after that extension, no progress was made either. Then a second renewal was actually approved in November of 2022, despite the lack of inspections and any construction having occurred. So that was pretty generous to the building department. However, after the second renewal, work did not commence, and the permit was again due to expire in May of last year. At that point, the owner then requested a third extension. That request was subsequently denied due to the history of no progress and lack of inspections. And then additionally, very importantly, the respondent had now exceeded the maximum allowance for 37 months of occupancy, pursuant to that temporary occupancy code in Part 310. And all during this time, code enforcement had continued to receive complaints about things like generator running and things of that nature. So here's that section of code I've been citing, and in the highlight section there, the upper section just says, yes, you can do this. We're supposed to collect a $2,000 bond for renewal. It does allow for one extension for an 18-month period, but in the pink there, but in no case will the temporary occupancy be permitted for 37 months of the original date of the permit. And I just want to include this slide because this became a main point of the arguments at the hearing, that the owner was arguing that they had completed substantial work. However, that work was some minor work done to start the process of installing a septic system. And the work was never completed, nor did it ever pass final inspection by the health department. And the work occurred actually in July of 2020, according to the health department. Which was well before the third extension request, so that really had no bearing whatsoever on the factors involved in the building official denying the third extension. And basically, they would have to start over at this point in any event because nothing was done to the health code. And I do have health staff in the room if anybody is curious about how that process works, but it's really not relevant to the current case that we have going on right now. So once there was no longer an active building permit, the RV and any other items that were on the property had to be removed because there's not a principal use on the property, not a main use per Article 302. So code enforcement issued an administrative warning at that time and gave the property owner 30 days to remove all the items before a fine would be issued. But the property owner did not remove the items and just continued to argue that the building permit should have been extended. So due to non-compliance, a penalty notice was issued. Here's a couple photos of the subject property and the RVs in question. Those from July, the one on the bottom is from July. So as is the right of the owner, they did appeal that penalty notice and an administrative hearing was scheduled. The Administrative Hearing Office, just by way of background, is not affiliated with the Code Enforcement Program. It's a separate third-party entity. It's staffed by volunteer pro tem judges or lawyers, so they're an independent arbitrator, basically. So at the hearing, the respondent presented some repetitive and mostly irrelevant evidence and testimony related to a separate issue that Code Enforcement has never been involved in any way, shape, or form involving the Wilcox Ranch Property Owners Association, and some kind of alleged activity that's been going on with that, but that really has nothing to do with the violation of the RVs being stored on the big piece of property. During the hearing, there was also continued arguments that the building permit should have been extended. However, the hearing office has no authority over that process. It's the building official's decision, and that decision had been rendered at least 6 months prior to the hearing. So again, the Administrative Hearing Office has no jurisdiction over the building extension permit decision process, and it cannot rule that that piece of this be revisited. Despite that, the hearing officer issued an order that stated the owner must request an extension of the building permit. Again, they don't have that authority, or seek a building permit by February 28th. And the word seek is very problematic, which I'll explain further in the next slides. The hearing officer based this decision on the following factors. This is what they said on the record: perceived extenuating circumstances of COVID. We're talking about this was just in December when we had the hearing. Perceived property title issues. Again, those are not germane. I believe the owner had performed substantial work in furtherance of completing the building permit, and that was the septic component back in 2020. So, in rebuttal to that, Code Enforcement argues there had already been an extension long ago issued in 2021 due to COVID, so those extenuating circumstances have already been addressed. Again, alleged property title issues are not relevant or germane to the RV violation, and the disputes with the Wilcox Ranch Property Owners Association has nothing to do with our case. We're not involved with it. They didn't even know it was happening during this whole time. And furthermore, Jonathan Belfort is the owner of record on the assessors, and he had been issued a building permit as an owner builder. So yeah, the word seek, ordering respondent to seek a building permit, that's such a nebulous and vague term. I mean, that could be a phone call to the building department. So Code Enforcement felt compelled to especially refute that component of the order because it's basically meetings. Regarding the extension, as I mentioned, they had already requested an extension of the building permit, and it was denied 6 months prior. And again, that's under the authority of the building official. It's not under the authority of the hearing office. Okay, cancel seek. And then the claim that the respondent had performed substantial work is just not supported by the record. There's no record of inspections having occurred. And so for these reasons, Code Enforcement felt compelled to appeal this hearing order. So in terms of the code analysis, again, this is a violation of Washoe County Code 110-306-35B, which prohibits outdoor storage on vacant lots. The property is considered vacant because it does not have an established principal use, such as a house. If you're curious, the definition of outdoor storage is the outside placement for more than 72 hours. And so again, to comply with the code, this portion of the code, the RV and any other items would need to be removed from the property, and any other accessory uses cannot be placed on the property until a main use is established. So again, in conclusion, there's no established principal use. The property is vacant for the development code. There's outdoor storage on the property, and it's not allowed.